Hi, I'm Jamie Johnson of the Johnson Law Firm, where we do estate planning and probate, and we do it well. Today I'd like to talk to you about, can you make changes to an existing estate plan? Well, one answer would be no if you don't meet the requirements of having testamentary. One would be no if you don't have the necessary testamentary. One of them would be no if you don't have the necessary requirements to make a testamentary document. If there's undue influence, if you're talking about an irrevocable trust, in which case you're going to need the approval of both the court and the beneficiaries, or if you've actually passed away. That's the time when you can't make changes to an existing estate plan. So if there's undue influence, you don't have testamentary capacity, if it's an irrevocable trust, or if you've passed away. Other than that, yes, you can make changes to an existing estate plan all your life. All wills are revocable. All you have to do is put a line through it, tear it up, write on them, it automatically revokes a will. A will only becomes irrevocable or becomes permanent on your passing. That's when it's known as your last will and testament, because it is the last will that you had. Any prior will is automatically revoked by the creation of the new will. Same thing goes for a revocable trust. It's in the word revocable, which means you can change it or revoke it or kill it, destroy it, remove it forever. A revocable trust allows you to make those changes. You don't have to seek approval of the beneficiaries or the court. You can make any changes anytime that you want, as long as you have the necessary testamentary capacity. When we make changes to wills, typically we either do it through a codicil, which is an amendment to a will, or through a new will itself. Now, when you create a codicil, you're actually writing up an amendment to the will and you're attaching it to the original will. So the changes that are made, when the will is read, people are going to know what you initially wanted, and then they're going to see the changes you made. So if you're cutting somebody out, or if you're changing the distribution percentages, they're going to know what the original percentages were and that you made changes. This can often lead to someone who's all of a sudden getting a lot less, challenging the will or challenging the codicil, trying to say you lack testamentary capacity at that time, and try to have the original will reinstated without the amendment. That's why if you're making changes to distribution, I often recommend that you just have a new will. They'll never know about the old will. They'll never know about the old distribution amounts. They just see the actual final will that is probated by the court. If you're only making administrative changes, you're changing, the executor or the backup executor or your guardians, things of that nature, then a codicil would be perfectly fine, because it's rare that someone's going to challenge a codicil on an administrative issue. Usually only codicils get challenged when you're talking about distribution, when you're dealing with someone's money. That's when there's a challenge. When you're making changes to trust, they're called amendments. When you're making changes to trust, they're called amendments. When you amend a trust, it's just like a codicil. You're making small changes to things within the trust, and it gets attached to the original trust. So when the trust is read or when it's being enforced, they're going to see what were the original distributions or the original administrative aspects of the first trust, and then what amendments were done. If you don't want that to happen, then you need to do what's called a restatement of a trust. When you restate a trust, you're basically wiping out the old trust, putting in the new, and no one sees the difference. They just see the restatement. So if you're going to be changing the distribution amounts, again, just like dealing with a will, if you're changing the money, the thing that's going to lead people to challenge it, then you're going to want to restate the trust as opposed to just doing an amendment. If you're only talking about changing trustees or some of the administrative powers, then an amendment to the trust would be just fine. Should you have any other questions about making changes to your will or to a trust, what would be best for you and how to go about it, feel free to reach out to the Johnson Law Firm. We'll be happy to answer those questions for you.